Been
You
one of
lawyer
those
to,
weeks.
you need a lawyer to sue.
Well, welcome everybody to the latest edition of 20-Minute Talks presented by Commercial Collection Agencies of America. I am going to promptly turn this over to Umberto Matz, the CCA of A president, who will be your host for the afternoon. Feel free, like I said, to put in the chat. Here it is, 60 degrees. The temperature where you're calling and where you're um, um, officing today. So,
So,
all right, Umberto, it's all yours.
All right. Welcome, everybody. Thank you for taking the time out. Um, our speaker today is Marc Ellison, co-president of the law firm of Tots, Ellison, and Tots in Houston, Texas. Marc has been licensed to practice law since November 1983 and has focused his practice on commercial collection law his entire 41 years of practice. Marc is an associate member of the Commercial Collection Agencies of America, the IACC, and a 30-year member of the Commercial Law League of America. He has been a frequent speaker in education programs for the Texas Bar and Houston Bar Associations. Besides practicing law, he enjoys spending his time traveling to and spending time with his two grandchildren in Chicago. Marc will be speaking to us today about the service of process through social media or email, methods of service which are not readily accepted, but are beginning to be approved in certain jurisdictions. So, everyone, please welcome Marc Ellison. Marc, thank you for joining us and talking to us today.
my pleasure. Thank you, Umberto. Thank you to the Commercial Collection Agencies of America for inviting me. I guess when I opened my mouth at the convention and talked about Texas now having service by social media, I put a target on my back, but that's okay. Um, I mean, we're all suffering with the issues these days of when you place a claim with a law firm and it has to go to suit. We're all dealing with problems with service of process, obviously. That's a big frustration for your offices, I'm sure, and for the clients as well. Some states are finally getting around to being a little bit more intelligent and realizing that we spend most of our time now these days either conversing through email or online and uh, looking at social media on a regular basis. So, since there's an increasing amount of usage of social media, states have started kicking and screaming to go ahead and promulgate rules that allow for service of process through either social media, email, and as I discovered, even text message. So, my familiarity is obviously with Texas, so I'll concentrate on that first. I must admit that I went ahead and after our meeting down in Florida, I went ahead and looked on artificial intelligence, ChatGPT, and went ahead and tried to research the various states that actually allow service by social media or by email. Got a nice list through ChatGPT, and then went back and started doing my own research and found that, well, you better start making sure that you have gone ahead and check out their sources uh, before you agree to tell everyone what they have told you. I found that the states of New York, California, Florida, Illinois, Nevada, Pennsylvania, and Maryland do actually have specific statutes that allow for service either by social media or email. Amazingly enough, Annette, Chicago is probably the most liberal one that I've been able to find. So we'll get to that later. In
Shocking.
Texas, yeah, in Texas, service of process is covered by our Rule 106, and it provides upon motion supported by a statement sworn to before a notary and made under the penalty of perjury, you have to list any location where you tried to obtain service of process on your debtor and show specific facts as to what occurred preventing you from obtaining that service. Normally, in the old days, we then would request, if we couldn't serve an individual, we would request substitute service by serving anyone over the age of 16 and attaching the citation and the petition to the door. But now we have a new section, Section 106B2, that says you can serve in any other manner, including social media, email, or other technology that the statements or other evidence that you provide in your motion will show that this service will be reasonably effective to give the defendant notice of the lawsuit. So what I've done is I gave Annette a form that we've been using lately and a proposed affidavit to just show you what we have to allege in the various motions. So in determining whether or not to permit service of process by either social media or email, the courts, what we find, and the comments that were made by the Supreme Court of Texas say that you have to consider whether the technology actually belongs to the defendant and that they regularly use it or recently use that technology. So what does that mean? With regard to email specifically, if you're attempting to serve by email, you might have a harder time if you find an email address for the defendant that begins with the word info or accounting or legal at, because the courts want to see it being more devoted to a specific person that is the subject of your lawsuit. So, and you also want to see in our finding, in our experience, that it's got to be filed by at Gmail, at Yahoo, or something very specific, or even if the debtor has their own specific domain tied to the business, but has a specific person's name. The same is true for TikTok, Instagram, Facebook, and the other social media services. In order to go ahead and obtain service of process by these methods, you're going to have to show that they are a frequent poster, frequent user of that service, and kind of like a proof of life kind of situation. So what do? You go ahead and attach to your motion and the affidavit instances where you have had either email exchanges, and it's got to be recent email exchanges, or recent postings that have occurred via social media, and attach that to your motion. It's a lot harder to serve, in our experience so far, a business though via social media, because as you may have experienced in looking at ads that are placed on social media or postings for businesses, a lot of times the contact information is, again, info at or accounting at and things like that. So there's my affidavit that I normally present. What I've gone ahead and done is I've prepared it in Word so that you can go ahead and basically cut out, add to, etc., fit the situation. One thing we've had recently with the local courts is a lot of them have denied motions unless you do provide recent contact. And when they finally do allow our process server to go out and make service via social media, they will not grant a judgment unless, for example, on email, you have a read receipt that comes back to the process server that he has to put in his return. And one court just recently, I talked to my process server today, he said they're making him send everything 3 times. So not only via email do they require the read receipt, but they also want you to attempt 3 times lately sending direct messages via either the Facebook platform, Instagram platform, etc. You want to provide as much information as possible, and the more information you have, the better. If we use email, we like to go ahead and take email contacts that we've had with with the debtors ourselves, and hopefully able to also show in those email attachments that it is signed by e-signed by the individual, or it at least shows their business contact information. You do need to be careful. I know that one of the comments that Annette made was, what are the ethical considerations? Well, ethical considerations are you should be careful in what you attach to your request for service by that method, only because of the fact that if there's privileged information or information that you don't want to be utilized later, if the case is contested and go to trial, you better screen carefully what you attach. One of the practical tips that I read was, as far as service via social media, is you want to consider the age of the person if you know. The younger the person these days, millennials or Generation Xers, the more likely they are to use social media in their everyday contact with the outside world. So if you have that information, you want to put that into your motion as well. In Texas, we have to go ahead and utilize a process server to actually carry out the court's requirement for whatever methods you choose. And again, they're not mutually exclusive. We found that if we can get Facebook information or Instagram information as well as an email, we're going to utilize both. As I'll speak later, Chicago or Illinois even allows service by text message. So we would even encourage you to add that as well into your motion if you have a person's cell phone address or cell phone number, excuse me. As I mentioned, there are other states that are utilizing this particular method of service now, and I'll go through a few, and I think Annette had that list. Let's start with the California Code of Civil Procedure. In 413.30 states, where no provision is made in this chapter of other law for the service of summons, the court in which the action is pending may direct that summons be served in a manner which is reasonably calculated to give actual notice to the party to be served, and then proof of service must be made as prescribed by the court. If we go to the Florida statutes, the Civil Practice and Procedure Code in Florida, 48.102, also allows for service via electronic service, email, or other technology if after due diligence you show that you've been unable to effectuate service through the traditional means. Again, the courts also are seeming to require, and it makes sense, that you have to at least allege with some certainty that you know that this will be sufficient in providing the defendant with notice of the action against them, as well as the time periods for when they can go ahead and file an answer to the proceeding. As I mentioned, I'll go through Illinois. I like Illinois better, as if you look at section 102F of the Illinois Supreme Court rules, they talk about, again, serving documents electronically, either through email, through social media service, and even again through text message. In the affidavit that supports the request, you must give the reasons why you believe the defendant has recently utilized that particular method of contact, and show how they remain active on social media. We look at Maryland's, they're trying to say that with evasion of service, the court can go ahead, again, with proof by affidavit and evidence, um, allow other means of service as the court deems appropriate. So the court has full and complete discretion. New York, the civil practice law and rules, section 308, 5, and 6, allows service upon motion with notice, without notice, directing one means of service either through social media or email, and make certain that you, by affidavit, list that the defendant, through regular solicitation or advertisement, has held out that email address or that Facebook direct message address to be theirs specifically. Or as Nevada is concerned, their rules of procedure 4.4, as I pointed out, state that in addition to other service methods, the court may order a plaintiff to make reasonable efforts to provide additional notice of commencement of an action via certified mail, telephone, voice message, email, social media, or other method of communication. So Nevada is allowing even through text messages, from what I can tell. And Pennsylvania will be the last one I discuss. And it's also Rule 430A, which allows through affidavit and evidence the right to go ahead and proceed with service via email or social media, as long as you give reasons why, with particular evidence, this would be the best method for service. Now, from my experience, again, each court in Texas has turned out to be a lot different than others. Some require you jump through many different hurdles. They allow this as a last resort. So first, rather than allowing you to, after you've tried your traditional method of service, rather than allowing you to go straight to email or straight to social media, they're still requiring us to try the substitute service via posting on the door at the usual place of abode or something of that nature. So you're talking about getting maybe 4 to 6 months down the road before you can utilize this particular type of service. And other courts we find are adopting this method, and it's usually the younger judges. So what can the agencies do to help us out? Obviously, check with the clients, check with your investigators or your collectors, and see what you can do to provide us with email addresses, Facebook contact, Instagram contact, TikTok contact, and even cell phone numbers if possible. We just have to make sure that we don't violate, obviously, any fair debt collection or any state law that prohibits contact by certain methods. Now, I don't know, I went pretty quickly, but does anybody have any questions that they want to ask?
I have a question, and actually, this question is for the entire audience. When you receive email or when you send emails, how many of you utilize read receipts? Okay, we have a few.
I do sometimes.
Okay. And then conversely, when you receive emails, at least in Outlook, it comes up with a little message. Do you acknowledge the read receipts?
I document my file.
Do you mean if somebody sends us a read request, like do we
Yes.
actually kick it? I Yeah, it depends if I like the person. I mean, really, that's the honest truth. I mean, if I don't want my read receipt to be acknowledged on the other side, I sometimes hit no, on purpose. Like honestly, um, I think the read receipt is great. Um, but sometimes the courts are really wanting an exchange, I think, which is what I think Mark was alluding to. Um, and so that's when, either in the collection notes that the collection agency sends us, if they do a copy and paste of the email exchange, if it's recent enough, obviously if it's from like 2016, that's not going to be helpful. But if it was like last month, or if there's an email exchange between the attorney or the paralegal and the debtor, as they're discussing the account, sometimes that might appease a judge, but they just want to see that if you're going to serve somebody by email, that's actually their email and it's an email that they're currently using.
Well, what I found in a couple of the judges in talking with my process server, he said that they are requiring that if they're serviced by email, he has to provide information proving or swear to the fact that he received a read receipt. Have you had many instances where you've gone this route, Matt, and been successful?
I'm gonna be honest. I mean, I can probably count on two hands the number of times that I have moved for service by social media. Um, I have done it when I just have simply run out of options, but I try to and I try to have an email exchange, or sometimes I'll use the credit application, as an exhibit, because I will have an email address. My fear is always if service gets invalidated, through a bill of review or some other mechanism and the statute has run, then I'm in the grease. And so, I will recommend service by social media only when a client is just really super unhappy. But I mean, at the end of the day, my practical advice is if we can't even find the guy and he has no assets, what are we doing? We're just
Yeah,
creating an extra work for everybody. So like, why are we really doing this?
yeah, that
Um,
makes perfectly sense.
and so I sometimes feel like we have a saying in the office that says work the file, not the action. And I sometimes feel that trying to get service and a judgment is just working the action, and when we're not really working the file, and working the file might be to tell the client just stop, like this is ludicrous. But I understand that we're in a service oriented business and sometimes we have to do this. But I will admit I'm a little gun shy, but I think this is a great topic, Mark. I think you've hit it perfectly on the nail on the head.
Well, certainly, thanks, Matt. I appreciate that. But some clients get very frustrated, obviously, if they see the fact that this debtor is active on Facebook or active on LinkedIn or even active on any other social media. So we give them the option. I haven't always gotten a, a positive answer from any of the agencies before, in the limited instances where we say this is our last resort and we can do this, we can try this. And we also have the instance where the judges are very squirrely right now, even though, Texas is backward and debtor oriented as it is. I was very surprised they added this particular provision to Rule 106 for substitute service.
I noticed that like in the family law area, this seems to be a little bit more common, like with
Correct.
spouses serving each other on Facebook. And when we first started looking at it, that's actually where I went to go get help, was with the family law section.
Mhm.
Um, but yeah, I think I've always wondered too. I know that um, when you post something on the door, or when you file something, it's a matter of public record. But also always wondered, like, does that just invite a fight, of disparagement or something? I just can't imagine. But people that get upset just end up filing silly things, and then you end up having to fight silly motions.
Yeah, true. Roxanne, to answer your three questions, yes, LinkedIn would be one of the methods by which you could serve. Um, let's see, isn't this when the debtor is evading? Yes, this is when the debtor is evading. Obviously, when they are evading, and you've tried traditional methods of service against an individual, then you're going to either want to attach to the door if you can gain access to their property, and serve anyone over the age of 16. But this is the most desperate method, by social media, email, because I think it does, at some point, it may invite a lot of bills of review, as Matt says, or motions to set aside judgments at some point in time, saying that they didn't receive or didn't understand the notice. I couldn't find much in the way of any case law uh, at this point. I think it's still in its infancy, so that is a problem. The oldest case I did find was a case that involved just family law services, as Matt mentioned. So, as far as positive results, from our experience so far, we've gotten two or three judgments. That's all on about 8 or 12 attempts. And we've had several denials from the court, despite all of the evidence we've provided them with, because they're just nervous. Again, I think some of the younger judges are more willing to do it than the older judges.
Mark, that the fact that you said about the younger judges, are you finding that the process servers could be younger are younger as well? Because they would have to be apt at, knowing all the social media platforms.
Um, the Yeah, I think the particular industry is going younger and younger. We have a guy that's probably close to my age, maybe 60, who we've counted on for as long as we've been doing this, or uh, probably the last 20 years. He told me today he's gotten off of LinkedIn because for service through LinkedIn, they're charging him $50 a month, and he just doesn't serve enough yet. So, but he is doing it through Facebook and Instagram, not only for our office, but for other offices as well.
I had a second question. Is the cost less expensive?
Not right now. No, it's about the same.
Okay.
It's basically whatever you're paying the process server and whatever the court is charging to issue the paperwork, if they charge.
So being
Better
one of
for
the older people that's not on social media, so I don't fully understand it. So if you do serve someone on Facebook or LinkedIn or something like that, is is there some sort of a read receipt?
I'm not aware of that. And what you're doing is you're not posting it to their page, obviously. You're trying to find their handle, or I call it handle, and sending a direct message. So you really, I'm not aware of a read receipt for social media.
I have a question. On LinkedIn, I didn't know there was a chat method. So are you able to chat them individually to serve them that way on their LinkedIn profile?
That's what my process server tells me.
Oh, okay. On Instagram, there are read receipts. On Facebook, there are read receipts as well.
Oh, well, thank you.
You're welcome.
And then on some phones, when you do send text messages on phones, they'll come back and say read or just delivered.
Oh, absolutely. Even on the iPhone now, if you they just recently changed the program so you can see on Android phones whether or not they in fact read the
Oh, yeah,
message.
you're right.
Yeah, I think on instant messages, you also notifies if it's been read or not. I'm not sure
Mhm.
though.
Yeah, I
It's funny
suppose.
because uh, I was just going to say it's funny because in 3 years this conversation is going to be completely different, right? So I just think it's kind of ironic when we have these topics and we're right on the precipice of this exploding. Robert, I'm sorry, go ahead.
I suppose if someone were to get served on social media, whether or not they read it with a read receipt, I guess that would only come into play if they never posted anything again. But if they posted something after that, I'd say it's safe to assume they read it or they got it. So
Yeah,
I don't think, right.
excellent point. And when we go in and try and obtain a default judgment, that's probably something that I should utilize.
Yeah,
Not,
they know you got it if you
oh
posted,
yeah,
three things after that.
sure,
And
sure,
if you log into LinkedIn, every time I log in, I see like a million things. So
right,
you have to go through them. So yeah.
sure.
And on Instagram, I don't think you have an option to turn off your read receipts. So like that's a good avenue to take because it's like permanently on.
I'm going to go ahead and do that on my Instagram in a little while just do a test with someone.
There you go.
And I'm just learning myself. So, I mean, we've been using it only for about maybe 6 to 8 months.
It's an awesome tool.
Yeah, that's great.
Yeah, I think this has been a really great topic. Does anybody have any other questions?
The
I
only thing,
do.
oh, go
Oh,
ahead.
go
I'm
ahead, Donna.
sorry, Mark. So as I guess it's kind of for all of you, and especially like Matt, I know that we do a lot of business with Matt's office. As an agency that's forwarding these, if we have current emails or confirmation of the email addresses, would it be beneficial when we're forwarding these files out to you to include that information with the media that we are sending so that you're already guaranteed in some way to have current information?
Well, that's what I was in fact suggesting that to provide us with as much information when you're forwarding the claim. So if you do have email addresses, if you do have evidence that you've been able to contact either the client or the agency has been able to contact the debtor through email, we would love to have that information, as well as again, if you've seen them on Facebook or they have Instagram presence, something of that nature, let us know that. I know when we do our reports to our agencies suggesting suit, our in-house investigators will always pull up and see if they have a social media presence. Even if we never need to go this service route, we'll have that information in the files saying that they have an active social media presence or Google is reporting that the location is closed. So we do go through that step. We may not always tell you that, but if the client's on the fence about thinking about uh, authorizing a lawsuit, then we'll add that information in.
Okay.
Usually I take the emails I get from the debtors and include it all in my package when I send it off to the law firms, just so they have documentation of the conversation.
And we
See,
do.
and that's what's helpful is that email exchange back and forth, because then the court can look at that and say, okay, yeah, this isn't just an email address that you got off a TLO or an email address that you got off a credit app. Those other forms bolster, and support an email exchange. But the fact that the court can see a back and forth, the court can say, okay, yeah, if Matt or the prior processor or somebody sends him to something to this email address, I feel comfortable that they're going to get what was sent out. And that's what's important. If you include in your package a Facebook history and all the Facebook posts are from 2016, no court's going to authorize the posting of anything because they're going to say, well, the person's not active.
Yeah,
So it's got to be current and it's got to show some sort of activity, like Mark said.
it's probably got to be within the last 30 days. Anything older than that, even if it's an admission in an email by the defendant that they owe the debt, is still going to be too old if it's more than 30 days.
But like Rock said, these people are evading service. So, it's a last ditch effort. And if you can get a court to do it and you're okay with the risk that, you may end up with the judgment being reversed if down the road, if they say they never got it, maybe this might be that 1 in 100 that might work to get the debtor's attention.
Correct.
Well, and I think just from a client service point of view, even if it is a last ditch effort, at least it shows the client that we're making that last ditch effort. And even if it ultimately gets reversed, that's on the courts. We're doing the best that we can, but if the courts are, ruling against us, again, I think from a client service point of view, that can be spun that, everyone's working this file really, really hard.
But at the same time, we also need to keep in mind that, we might be beating a dead horse at that point.
Agreed. But I think that also comes back to, and I'll just use myself as an example, when I first started doing forwarding and I was a little more insecure about closing some large file, you do have to know when to close a file, and ultimately, if there's just a couple more zeros on it, it doesn't really matter. If it's garbage, it's still garbage.
0%, 0 of 0 is still 0. 100% of 0 is still 0.
Exactly.
That's correct.
All right. Well, I think this has been a really interesting session. Mark, thank you. Until you brought it up in Delray, I hadn't heard about this. So I think that this has been enlightening for many of us.
And I know I went a little quickly, and I hope I didn't confuse too many people, but we're including myself. But
I thought it was.
I
appreciate that. I appreciate
definitely fantastic.
Yeah, it was very informative.
Thanks, Mark. Appreciate it.
Thank you so much.
you.
All right.
Thanks for the time.
Thank you, Mark. Thank you, everyone, for attending. We appreciate it. And,
Thanks, Mark.
This was
Thanks,
great,
everyone.
Mark.
Happy
Happy holidays, everybody.
Happy
Happy holidays.
Stay warm. Okay. Bye.
Take care, everybody.